New orders in the Durham prosecution against former Clinton campaign lawyer Michael Sussmann. You can see Judge Cooper issuing this on April 25th. It's 6 pages long. We're going to go through it. It's addressing two pretty important issues: whether certain evidence can be admitted or whether it's going to be precluded, kept out of the jury's eyes. And number two, whether a witness can testify. In this case, very important witness, guy by the name of David Martin. You can see supervisory special agent. We're going to learn more about him. And we're also going to hear from Judge Cooper throughout the order as he's explaining what type of evidence must be precluded and what type of evidence can come in, what evidence the jurors can hear. The big order starts like this. Defendant Michael Sussmann, seen here, we've talked a lot about him, charged with one single count of lying to the FBI. And this is a very important concept, this concept of being a material lie, because this is a legal term of art that they've been fighting over for quite some time. It's okay to meet with the FBI and talk to them about certain things, but you can't say things that are dishonest, that are lies. So we got to be very clear about what that conduct is, what type of language constitutes a lie, what is material, what's not. And so we'll see what that means as we go through this order. The charge arises out of a September 2016 meeting between Sussmann and the FBI. And remember, that's in the months leading up to the election, gigantic election between Trump and Hillary Clinton. Sussmann working with Perkins Coie, Mark Elias, and they were working to create this fake narrative that would help get them an advantage during the election season. Sussmann goes, he meets with the FBI General Counsel James Baker, a lawyer, knows better, during which time Sussmann provided Baker with 3 white papers and associated data files saying that he would substantiate a reported link between Russia's Alpha Bank and Donald Trump's presidential campaign. Sussmann shows up at the FBI's doorstep. I've got the goods. I've got documents here going to show that Trump and Putin are in bed together. Here is the connection through Russia's Alpha Bank. False statement charged in the indictment because he showed up there and he told the FBI, I'm not here on behalf of anybody else. Then he turned around and sent Hillary Clinton a bill for it, literally. False statement charged in the indictment does not relate to the substance of the shared material, but rather to Sussmann's alleged erroneous statement that he was not attending the meeting on behalf of a client. Sussmann saying, I was just wrong about this. The FBI, Durham, the government saying, no, you lied. You knew better. You're a lawyer. You were there on behalf of the Clintons. You helped concoct this entire narrative, and you showed up and said otherwise. The order continues from Judge Cooper, says trial is set to begin next month. In May, we're ready for it. The parties have been filing a bevy of pretrial evidentiary motions. We call these motions in limine to address preliminary issues, get all this stuff sorted out before you're sitting there in front of the jurors and you have to kind of go through this right in front of everybody. You want to try to do most of this outside of their eyeballs. Here, the court writes, at Mr. Sussmann's request, the court heard expedited argument on 2 issues that bear on the preparation of the defense. So the defense Sussmann's team says, Judge, we got to really resolve these issues so that we can better prepare our defense. Because if it goes this way, we're going to do this. But if it goes that way, we're going to do that. Here, 2 issues. Number one, whether Sussmann can preclude evidence about the accuracy of the data that he gave to the FBI. So let's break that down for a quick moment. Remember, when Sussmann came to the FBI, he had a bunch of documents. It was the Steele dossier, 3 white papers that the court referenced earlier. And he's saying, okay, well, I showed up with those documents, but we can talk about that to the jurors. We can show them the document, whatever, all of that's fine. But I want any conversation about how I got those documents, where they came from, the gathering or the accuracy of the data, what's in those papers, how we got that, Steele, all of that. Well, I don't want to talk about any of that. And he's going to make the argument, well, it's not relevant. I don't really think that the juror should hear that because we've got all sorts of other evidence and it really has no bearing on the actual conversation that Sussmann had with the FBI, whether he lied to them or not. Well, the documents are sort of irrelevant because the lie is not about the documents. The lie is about whether he was there on behalf of Hillary or not. Turns out he was. As a defense attorney, one of the reasons why you might want to keep that information precluded would be if you're a juror and you got information that showed that there was a massive conspiracy, that all these people were working together. If you heard about Steele and you heard about all of the different connections with Perkins Coie and Mark Elias and how everybody was involved in this, you might take a look at Sussmann and go, well, you're just the front man for a gigantic conspiracy, and you might attribute all of those nefarious acts onto your own client. And so you might want to protect against that if you're the defense. Same sort of works in reverse if you're the prosecution. You want to show all of that. You want to say, yeah, look, this isn't about a guy named Sussman who showed up just with a stack of papers and said, oh, golly, I don't know what's in these white papers, but I guess I'll turn this over to you, FBI. And they say, are you here on anybody's behalf? And he says, no. And they go, okay, well, that makes sense. Prosecution's going to go, that's a ridiculous story. That's nonsense. What we're talking about is a gigantic conspiracy, a hoax, a big group of people working together to derail an election and create a fake narrative that would further their political objectives. They want the jurors to see all of that, and the defense, of course, doesn't. So they filed the motion to preclude that, as well as another motion to exclude the government's proposed expert witness, this other special agent from the FBI who's going to come and do the same thing. The prosecution wants him to come and talk about all the details and technical data to show why this whole thing was ridiculous. And the defense, of course, doesn't want that to happen. They just want to say that old Sussman was just a confused, good citizen, was there with a big dossier and just wanted to turn it over to the FBI. The whole thing's a big misunderstanding. He just wanted to help. And if they are able to limit the extent of his back-end operations, that's going to serve their cause. Durham, of course, wants them to see all of it. The judge writes, as explained below, the court will grant in part and deny in part each motion. 2 motions from Sussman, 1 to get the data out, number 2 to keep the expert witness out. Some granted, some not. So let's break this down. Judge Cooper writes, the court also reserves certain issues for further evaluation after this week's hearing on the remainder of the evidentiary motions. And we know this is coming up. We have oral arguments scheduled later in the week, which of course we'll break down. We jump into the order, Section A, motion in limine on the data. This is the argument from Sussman that anything that is in the white papers or the dossier or what was presented to the FBI, he's saying should be precluded. It's not relevant. It has no bearing on what the conversation was between him and the FBI and whether or not he lied to them. He says the court begins here with Sussman's motion to preclude the introduction of the evidence about how the data he provided to the FBI, the dossier, how it was gathered, whether it was accurate, and purportedly related information in the dossier put together by the former British intelligence officer Christopher Steele. So he says, we're talking about this issue. Let's be clear. The court will reserve judgment on much of this motion. So I'm not going to issue all the details right now. He says many of these issues are linked closely with other motions in limine, which haven't been argued yet. And we know that many of those are coming up this week. But he writes, however, whether and to what extent the court will allow in evidence about the data's accuracy bears directly on Sussman's request to exclude the government's proposed expert testimony. In other words, these two things relate to one another. Here, the data and the accuracy might be something that special FBI agent is going to testify about. So if we're going to talk about some of that data, we may need an expert witness to come out and explain the data. And if we don't have that data coming in, well, we may not need that expert witness. He says, with respect to those issues, the court will grant the motion in part and deny it in part, although it again reserves judgment on certain issues. And many of you have followed along on some of the other trials we've covered here, cases like Kyle Rittenhouse and Ghislaine Maxwell and several others like Derek Chauvin, where you'll see the judge will sort of say, I can't really rule on that yet because I have to wait until the questions and the line of questioning, the inquiry develops a little bit, and then we'll start issuing some rulings. And judges have different styles on how they handle these things, but here you can see the judge is allowing a sort of a loose framework to be created, saying he's going to reserve judgment for certain issues. Continues on, says, the court begins with the parties' concessions. And here we talk a lot about the scope of the argument and what is included in the argument or what is excluded. And oftentimes we see that different sides will fight over that. They'll fight over the scope of the argument. The judge is using similar language here, saying, there are different concessions here that make my analysis easier. Writes, this narrows the field of play significantly. We don't have to argue about a bunch of stuff if you're willing to say we're not going to talk about this and you're not going to talk about that. He says in its opposition brief, the government explains that should Sussman, right, he means Durham is saying, should Sussman, quote, concede or decline to dispute the fact that no secret channel of communication actually existed between the relevant computer server, Trump, and Alpha Bank, then Durham is not going to even seek to offer proof concerning the accuracy or the reliability of the data. And he's referencing this right from the government's motion. their opposition to the defendant's motion, this is what they responded to when Durham said, we want to keep all this data out. Durham said, look, we are okay to not even offer proof of the accuracy of or the reliability of that data if you're willing to say or not going to dispute the fact that there was in fact no actual channel of communication. So both sides are kind of taking this out of the argument. The government is saying if you acknowledge there was no direct connection, or you don't make that argument that Trump was in fact communicating through Russian banks called Alpha Bank, then we're not even going to argue that. We don't have to talk about it. At the hearing, the defense counsel stated that they will not seek to affirmatively prove the existence between Alpha Bank and Trump campaign, which makes sense because they can't prove that. And they're not going to try. And so the government in Durham and his prosecutors are now saying, all right, well, we're not going to try either. If you're not going to try to prove that, we're also not going to try to prove that, because that's not really what the point of this case is about. With that representation, the judge is acknowledging both sides are giving a little bit here. The court will hold the government to its word and will not allow it to put on extensive evidence about the accuracy of the data Mr. Sussmann provided to the FBI unless Mr. Sussmann does so first. And I think this does make sense. If the charge here, the indictment, is lying to the FBI, remember that the real portion of the lie that we're talking about, that actual conversation, wasn't necessarily about Sussmann delivering a dossier filled with lies. It was the fact that he was there communicating to the FBI, saying that he wasn't doing that on behalf of another client. That was the lie. It wasn't that the dossier was full of garbage, which we all know it was. It was that he was there saying, I'm not working for the Clintons. And so we got to make sure we're sort of teasing out those issues. The judge is saying, yeah, the dossier, I'm not issuing a ruling, or we're not even going to argue about the accuracy of it. It may be accurate or not. Who knows? The judge says that's not relevant. The indictment said he was charged for lying, so we're going to stick to that. Judge Cooper continues, says that does not end the inquiry, however, as the parties disagree now about, number one, what remains of the government's data-related evidence. They've still got a lot of it. Durham has USB drives out the wazoo. And number two, what Mr. Sussmann could do at trial to put the data's accuracy at issue. And so the defense is now saying, well, Judge, this is a little bit of a precarious position for us to be in. I mean, what if we just go down a general line of questioning and somebody says something and then the prosecutors over there say, oh, boom, bingo. Now we can get to use all of that external data. We get to bring that in because the defense opened the door. They sort of, made a mistake and somebody said something, and now the government comes back out and says, well, we got to rebut that claim, Judge. And now the only way we can do that is with all this external evidence. You can see now the defense is sort of saying, Judge, we don't want to tiptoe around this issue. Help us out. Judge writes, starting with the first question, the court will permit the government to put on evidence reflecting the FBI's ultimate conclusions. So they can talk about FBI agent, anybody, general counsel over there, can talk about the general conclusion. And at this moment, the court understands that to be Alpha Bank and the allegations were unsubstantiated. We're unable to make those connections. Says as well as the particular investigative and analytical steps that the FBI took to reach them. So we see a standard there. Particular investigative and analytical steps. So what did the FBI do to get from point A to point B? Sussmann shows up. I've got this dossier. I'm a good citizen, not here on behalf of Clinton. Presents all the materials to them. They do their investigation. What steps particularly and what steps analytically did they take to do and reach their conclusion? Here he says that is going to be relevant. We can get that stuff admitted into court. But he says such evidence is relevant to the government's theory of materiality, which is why it's coming in. Their theory being that Sussmann and his alleged statement that he was not representing a client caused the FBI to handle the investigation differently than it otherwise would have. If Sussmann would have been honest and said, yeah, I do have a lot of very important information, but guess what? Darn it, I happen to also be working for Hillary, who's up for election here in about 35 days. Would that have changed how the FBI processed this whole thing? Probably. You'd think so. I mean, if you were in that position, you might think, well, that's curious. Now that information might be compromised or tainted. It's less reliable here because Sussmann has a conflict of interest. His boss wants to see Donald Trump taken out and would be very gleeful if the FBI came and endorsed this dossier and said, yeah, it is a big problem. They could run with it and go indict him and take him off the playing field, which is something the Democrats like to do. Judge continues. He says how that investigation ultimately proceeded and the conclusions it reached are relevant to that inquiry. FBI had to make decisions. Part of the government's theory here is that there was a misrepresentation from Sussmann about why he was there. That was material to the FBI's decisions in their further investigation. It continues. Judge Cooper writes, some of the evidence the government discussed at the recent hearing, though, does not fall into those permissible categories. So while we can talk about the particular investigative and analytical steps, other things not. In particular, the court will not allow representatives of the companies who maintain the servers that purportedly receive communications from Alpha Bank to testify about their involvement with the FBI. There were other people, Fusion GPS or other companies that were maintaining servers. Who knows specifically here, but the judge is saying we're going to limit it to this narrow scope. Those other people just aren't relevant. He says, even though the government thinks they're relevant, he writes, contrary to the government, Durham's assertions, says this evidence does not appear to be probative of why the FBI took the steps that it took in their investigation. It doesn't help us determine whether they took one course of action or another. It's not probative or material enough to be relevant that we're going to let it in. He says, and it is at a minimum unnecessarily duplicative of other more direct evidence of the same. He's referencing a 2013 case from the DC Circuit saying that where there is duplicative evidence, if we have two things that tend to show the same thing, well, we don't want to just start layering on a bunch of duplicative evidence. Here in this case, we've got enough evidence that Sussmann sat down, had conversations with the FBI, and purported to be not there on behalf of anybody else. And so we're talking about that materiality of what his statement and whether or not that influenced the FBI. Here, whether the people who worked on the servers to help him create some of this data, that's not really as relevant as to whether he lied specifically to the FBI. For the same reasons, he writes, the court will not allow extensive discussion of another federal agency's investigation into the same data that Mr. Sussmann provided. What other agency is he talking about there? Oh yeah, the CIA. Remember them? That's because Sussmann went over and met with the CIA after he met with the FBI. Except to the extent that agency's findings and analysis had a direct bearing on the course of the FBI. So remember what the judge is doing again, narrowing the scope. He's charged with, in the indictment, with lying to the FBI. The CIA conversation is sort of not necessary to the underlying base issue. He continues, finally, the court takes a moment to explain what could open the door to further evidence about the accuracy of the data that Sussmann provided to the FBI. If the defense does something and they open the door, if they crack that shell a little bit, then the prosecution can just drive a bus right through. As the defense concedes, as Sussmann's team acknowledges, such evidence might be relevant if the government could separately establish, quote, what Sussmann knew about the data's accuracy. So if they can say Sussmann showed up there and he knew that maybe the data was problematic, maybe that changes the equation. They write, if Sussmann knew the data was suspect, evidence about faults in the data could possibly speak to his state of mind at the time that he met with Mr. Baker at the FBI, including his motive to conceal the origins of the data. If he knows the data is problematic, he says this thing's a hoax big time. But if I go and I tell the FBI that I'm working for Hillary Clinton, they're going to go, well, we better really look at this then. So they might find the hoax a little bit more easily. By contrast, Sussmann would not open the door to further evidence about the accuracy of the data simply by seeking to establish that he reasonably believed the data were accurate and relied on his associates' representations that they were. So if in the line of questioning, if Sussmann takes the stand and they ask him questions, did you know anything about this data? And no, I just thought it was reasonable information provided by our research team and I took it over because I'm a good citizen. That alone is not going to be enough to open the door. But he says such a defense theory could allow the government, if that did open the door, that would allow the government to introduce evidence tending to show that his belief was not reasonable. For instance, facially obvious shortcomings in the data or information received by Sussmann indicating relevant deficiencies, but it would not open the door to a lengthy and complex exploration of the underlying data. So just allowing a surface level discussion of that, but not saying, okay, we're going to bring in all of the people who run the servers and we're going to bring in all these special agents and expert witnesses to verify the data. This isn't a trial about the legitimacy or the accuracy of the information. It's about Sussmann and his lying to the FBI. He says, I understand these are broad guidelines. Beyond those broad guidelines, the court will reserve any other judgment about the issues raised in the motions about the data as the trial unfolds. Before we get to paragraph B, the second part of this order where the judge is issuing a ruling on whether or not a special agent can testify, we got to learn a little bit more about the special agent, this guy, David Martin with the FBI. And this is a clip from a website where he was giving a speech some time ago, but they have a little bit of a bio here. They say he's part of the FBI's elite investigative rapid response team for computer intrusion incidents. Really, just like what we're talking about here, apparently. A native of Denver, 15 years law enforcement with the FBI, been investigating computer intrusion since 2009. Cyber technical operations, Bachelor of Science, has a lot of different degrees and technological background certifications. His specialties include digital forensics, incident response, network traffic analysis, malware, reverse engineering, and writing ugly, poorly documented field expedient Python scripts, as well as a few more polished digital forensics platforms. He's a joker. He's got a sense of humor at the FBI. I think that's illegal. Somebody should call Merrick Garland. We have more. Paragraph B, motion to exclude expert testimony. The defense does not want him to come and testify. Seems like a pretty reasonable fella. So the Sussmann defense filed a motion to exclude him, preclude his testimony from coming into trial so the jurors can't hear from him. And the judge now is going to address that, saying, now that we've talked all about the data, let's talk about the expert witness who might be useful in explaining the data. He says, with this background in mind, the court can more easily resolve Mr. Sussmann's request to exclude testimony from the government's proposed expert, FBI Special Agent David Martin, the gentleman we just learned about. Writes, the district court has a gatekeeping responsibility to ensure that expert testimony is based on scientific knowledge that will assist the trier of fact to understand or determine a fact in issue, referencing another DC Circuit case from 2016 and the federal rules of evidence. So he says, the court will largely deny the motion and allow Special Agent Martin's proposed testimony, subject to some limitations consistent with the analysis above. So he is going to be able to come out and talk. Footnote 1 from the defense, Mr. Sussmann urges the court to exclude the expert testimony on the ground that the government noticed provided information that he was going to testify untimely and that it wasn't specific enough. Because the court will limit, the judge writes, Special Agent Martin's testimony largely to general explanations of technical data has always been a part of the core of this case, much of which Mr. Sussmann does not object to. Any allegedly insufficient or belated notice, he writes, did not prejudice him. The defense is arguing that Sussmann got notice that Special Agent Martin was going to testify late and therefore he should be precluded. The judge says, yeah, maybe it was a little late, but it didn't actually harm you, so you're good. Also writes, assuming that Special Agent Martin is qualified as an expert, the court will allow him to testify about 3 general topics. First and foremost, and most significantly, background information necessary to understand the relevant data, including basic mechanics, architecture, terminology, computer systems at issue. We got to learn about those things before we understand what data we're talking about. Second, the type of conclusions that can be drawn from analyzing the kind of data that Sussmann shared with the FBI. In other words, if we're going to be saying that Sussmann, by communicating to the FBI and providing them with these white papers, was promoting a material lie, something that caused the FBI to make an investigation go one way or another, we got to know kind of how the data might have influenced that. The jurors are going to have to understand that Sussmann came with something material or not. If he showed up with a comic book and said, look, Donald Trump's here. He's taking over Garfield. And then they would say, well, you're crazy. Let's see you out, please. Thank you. But if it's a material document and it looks like it was properly assembled and it was purporting to communicate a very severe threat, maybe the FBI would have received that differently. And third, the methods investigators would use to validate or further examine that data. Once the FBI received it, what did they do? All 6 proposed testimony topics listed in the government's opposition brief fall within those parameters. These topics are generally relevant to the theory of materiality that Durham and the government plans to pursue in its case in chief, and expert testimony on those subjects will aid the jury in determining the technical aspects of the case. The court will reserve ruling on any objections to specific testimony, though, until trial. Our final paragraph from the judge, he writes, the government suggests that Special Agent Martin's testimony may go further depending on what theories Sussmann pursues in cross-examination or his defense case. So Durham saying, Judge, look, I know we're talking about limiting his testimony to some degree. It could go out, pretty far depending on what the defense proffers forward. Consistent with its findings above, the court will allow the government's expert to testify about the accuracy of the specific data only in limited circumstances. In particular, if Sussmann seeks to establish at trial that the data was accurate and that there was, in fact, communications between Alpha Bank and Trump, then expert testimony from maybe somebody named Special Agent Martin could explain why this could not be the case. It would become relevant at that time. But what happens if Sussmann and his defense don't make that argument? Well, then it's not really relevant. But if they make that one of their defenses, now it becomes something the prosecution can talk about. But as the court noted above, additional testimony about the accuracy data, expert or otherwise, is not going to be admissible just because Sussmann presents evidence that, quote, he relied on Tech Executive One's conclusions, that's Rodney Jaffe, about the data, or, quote, lacked motive to conceal information about his clients. As the court has already explained, complex technical explanations about the data are only marginally probative of those defense theories. We're not going to just dump code all over the juror, explaining DNS and IP and UPS and zip drives and all of the different codes. The court will not risk confusing the jury and wasting time on a largely irrelevant or tangential issues. And the judge concludes, for the foregoing reasons, today it is hereby ordered that as to item number 60, defense motion in limine, this is Sussmann's attempt to preclude evidence about the gathering of data. You can see granted in part and denied in part. Granted that you can talk about it, you can introduce conversations about the data, where it came from, why it's useful, why it might have impacted the FBI, but you're not going to be able to get into gigantic in-depth exposés about where the data came from and DNS, IP records, all that stuff. Similarly, ordered defense motion, Sussmann's attempt to throw out the testimony of the special agent is granted in part, but also denied in part, depending on what the testimony shows or what the defense theories are. If they keep it narrowly tailored and they don't jump off into trying to prove Alpha Bank and Trump were all connected, well, then Special Agent Martin is not going to be able to talk about all of those things. The judge is going to try to keep this train on the tracks, keep the testimony focused about what's charged in the indictment, and we're going to continue to follow it. My question to you, of course, is, does this matter in any way? Is the judge's ruling, is their opinion or order going to lead to one type of verdict one way or the other? This is what attorneys fight over. These are serious motions and serious issues. Sometimes these are seen as little battles, but they can often lead to victories in the bigger war. So we'll continue to follow this. There's going to be a lot more rulings and more additional motions in limine and responses and replies. We'll follow it all the way to the end. I hope you join us on that journey. I would love it if you subscribed before you got out of here, invited somebody to join us as well. And I look forward to seeing you on the next one.